David Rivkin stays with us and will stay with us to the end of the hour. Then Heather McDonald on Trayvon Martin. Very interesting morning. It's not a relaxing Friday, but it's a very intellectually stimulating Friday. Let's go through questions, folks. We got a lot, so if you can put your questions succinctly, and we'll ask David to be as succinct as possible in answering. John in Sarasota, Florida. Go ahead, John.
Good morning, Mr. Rivkin and Dr. Bennett. My question relates to Judge Roberts upholding precedent, which I understand he's sort of come to do, and I wanted to see if that was the fact or if your guest agreed with it. In 1937, the Halbering v. Davis decision, the court upheld the idea that the federal government, the Congress, was responsible for the general welfare, and I was somewhat surprised that wasn't brought out in the oral arguments, but it might be in the written brief. Is Judge Roberts prone to uphold that as a precedent for the individual mandate?
Short answer is the general welfare clause is a limitation on taxing power because this mandate is not supported by a taxing power. First, because Congress did not use it as a matter of legislative reality, and second of all, it would be a direct unapportioned tax because it's not true tax on income. It would not work. So the general welfare clause here is irrelevant.
Okay, thank you. Quick question, factual question. Mike in Ann Arbor. Go ahead, Mike.
Yes, I have a question. I've heard the comments about and the criticisms of the Solicitor General and the Assistant Solicitor General. Does the administration have any option in picking another attorney, or does it have to be the Solicitor General? And if they can pick another attorney, my feeling is, since we have the greatest legal minds, supposedly the liberals tell us, living at 1600 Pennsylvania Avenue, why did the President of the United States, since he is a constitutional attorney, considered so great, why didn't he argue his own case in front of the Supreme Court?
I'll tell you, would have been better off with Rivkin, but if he could get him. But what's the answer?
Let me defend Don Verrilli, even though I don't know him, but I know Ed Needler, who, of course, argued a portion of a case. They're both very able lawyers. The media is spinning, and don't let them confuse you. It is a bad case. As I said earlier, you can get Cicero to argue it. You would still lose. It is not the bad lawyering. As to the president, not to be disrespectful to him, but I don't think he ever argued in court. If he tried to argue this case, I think we would have had a less impressive performance, but I could be wrong.
Is he allowed to? Does it have to be the Solicitor General?
No, he doesn't. Well, that does not. Sorry, I didn't answer the question. 99% of the time it's Solicitor General. There are instances, by the way, there's a sort of unwritten tradition. The Attorney General gets to argue a case or two. Deputy Attorney General gets to argue once. Associate Attorney General, it's considered to be a nice perk.
Okay.
But in a case of this magnitude, it would have been unheard of to have somebody other than Solicitor General argue the case. Okay.
David, too, I mean, again, this beating up on Verrilli, you say that the weakness was the case. Wasn't this, at least to me, just picking up intuitively, the four liberals, they didn't seem, much excited about it. You didn't get the sense from them that they were saying, well, you conservatives are outrageous. This is crazy. What do you mean they can't do the mandate? They were pretty muted, weren't they?
Bill, that is an excellent point. If you look at their usual demeanor, you cannot fail to notice how subdued they were.
Relatively subdued is a better word.
Again, let me say this. The four of them delivered in this way a subtle rebuke to Pelosi's, "Are you serious?" implying that this is some crazy right-wing nonsense, which we heard so many times in the beginning of the case, the years thereafter. No, I honestly feel, it's a guess on my part, I'm sort of psychoanalyzing them a little bit, they were not comfortable because they knew how fundamentally indefensible this mandate was. They also knew it could have been done differently. So they were not happy that the two political branches send this kind of bill to them.
That's nice. I mean, we can at least take comfort and encouragement in the fact that people, even though we may disagree with them, the liberals, take the Constitution seriously, know what a good piece of legislation is when they see it, and that recognition was clear enough in their comments.
This wasn't it.
Yeah, this ain't it. Yeah. Good. Bob in Dayton, you're on with David Rivkin.
Good morning. This is slightly off topic, I suppose, but I'm just wondering if the mandate is struck down alone, could HHS sort of put the mandate back in a backhanded way? They couldn't get cap and trade through, so the EPA comes up with rules that in effect create cap and trade. So could they, could she put something in that, more or less puts the mandate back?
The short answer is no, and I know what you mean about putting in a cap and trade for regulations. I'm actually involved in the D.C. Circuit litigation challenging EPA's greenhouse gases. There's a fairly broad language in the Clean Air Act, which I think EPA is using incorrectly, but there's something for them to use. Once the mandate goes down, there's really absolutely no way for HHS or any other government agency to come up with a regulatory facsimile for it.
All right. Let me ask you this. It's related. We had an email from Dr. Marty. Here's a likely outcome. The conservative judges and liberal judges split. Kennedy throws out the individual mandate but lets the rest of the bill stand. What about this? What does that mean?
Well,
and is the question meaningful?
No, it's a meaningful question. The supposition is that we'll have Kennedy being the decisive vote, and he'll join the side taking down the mandate. I consider that to be very plausible. I think it would not be just the individual mandate. What would also go down with it are the two insurance industry mandates, and that's the heart of a bill. Yes, a lot of stuff would remain. I hope the entire bill would go down, but what the question is asking is entirely plausible. And then, with the right outcomes in November, Congress would have to deal with it because it would be a mess. You would have thousands of pages worth of stuff. Taxes, for example, just to give you one idea, we have taxes on medical devices that are stifling medical device industry. All that was done to finance this kind of stuff. Well, what do you do with it? Well, that's a problem for political branches. The courts are not meant to be a panacea in such situation.
All right. Good. Okay, thanks. Let's see. There's so many more questions. Thanks, Bob. John in Blue Mountain Beach, Florida. Go ahead, John.
Good morning, Bill. Good morning, Mr. Rivkin. If the Supreme Court does decide to either strike down the mandate or strike down the mandate and leave the rest of the bill in place, how quickly or what is the time span for this taking effect on any change that they make to the bill?
I don't think I understand the question.
Go ahead, John. Try to get. When does it go into effect? If they say the mandate is gone, everything else remains the same.
Either way, either that they strike the entire bill or they strike portions of it. When do those changes go into effect?
Oh, then the court's decision. Well, then the court issues the decision, which would be in late June. You would issue a decision. It would issue what is known as the mandate. It would be effective immediately. So whatever portions of a bill are struck down, or a bill in its entirety, it's effective immediately. There's no sort of delay or waiting for an effective date or anything like that.
Well, let's say the mandate goes down, and they say the rest of it is okay, but that means it has to be fixed. Back to what you were just saying.
Well, no, it doesn't. No, they're not going to. Okay. The court would not say anything about getting it fixed.
Of course,
it would be an incoherent piece of legislation.
Sure.
Even worse than it is now in terms of Constitution would be fundamentally safe, but it would be up to the political branches. They can do nothing with it.
No, I misstated, but that would be up to the political branch. But if you throw a bunch of this back at the political branches, nothing's going to happen positively for Obama because you didn't have a Republican House when this thing passed.
Correct. Plus, nothing would happen in election years. So
sure.
This would be something on the plate. And one of the things, look, I'm not a political pundit, but certainly the Republican challenges, whoever is left standing by that point in time, would have to indicate what he will do as far as the health care.
Right. And he might say, let's just do something like Massachusetts. Or he might not.
Right.
I'm sorry, I made a bad joke. No, but finish your point. I didn't mean to interrupt you.
No, I think that this is, of course, the jobs in the economy, but it would be worthwhile to point out what would he do with whatever rump of a bill that remains. And, again, this is something that Congress would have to take up next year. How successfully that can be done, it's anybody's guess.
Well, I think let me make that guess in the political sphere. I mean, if the mandate's out and then the rest.
And the insurance industry mandates are out.
Yeah, right. And then say, okay, the political process now has to go to work. Obama's not going to see the light of day again on this thing. The thing doesn't have a prayer, it seems to me, in a second form. Not in an election year and not as long as there's a Republican majority in either house.
Understand one big piece, by the way, which I hope will come down, but if it remains, is the Medicaid expansion. This is another horrible and constitutional problem. Remember, it greatly burdens the states.
Yeah.
The choice between losing all the Medicaid money and having an immediate disaster and losing and incurring incredible additional expenses and facing disaster in a few years. So unraveling this ill-considered Medicaid restructuring would be a key task. That's something that has to be done because it's going to bankrupt states.
All right, we have time for one more question this segment, then we have a last short segment with David Rivkin. So if you want to get on, call us now. John in Winder, Georgia. Go ahead, John.
Good morning, Dr. Bennett. Good morning, Mr. Rivkin. Thanks for taking my call. My question has to do with all of these tens of hundreds, or it might even be thousands of waivers that have been granted. And I ask it not in the context of if this law is so great, why the need for even a single waiver, which is the obvious question, but in the question of the Equal Protection Clause. And my example is I could have a next-door neighbor who, just because he belongs to a union or works for one of these companies that have been granted a waiver, doesn't have to abide by the same law that I do.
Okay.
How can that be, and why hasn't the opposition made more of these waivers?
Okay.
Well, we've challenged the statute on what is known as a facial challenge. We have not challenged the statute as applied, which would deal with a question of implementation. Yes, politically speaking and sort of symbolically, the waivers have been accomplishing precisely what you said, which is if it's so great, why are you granting companies waivers? Whether or not the way the waivers were affected violates Equal Protection Clause, I don't know. I frankly doubt it. The government has wide latitude, particularly when waivers are temporary, wide latitude in providing transitional rules and whatnot in a variety of statutory contexts. I think it would be. I understand sort of your anger, but I don't think that's a fruitful way of challenging. But in any case, none of it was before the court because all those things are implementational and have nothing. It was not a part of our facial challenge.
I'm going to let Tim ask his question, but we'll get the answer after the other side. Tim, do it in 20, 30 seconds, please.
Yeah, thanks, Bill, and thanks, Judge Rivkin. I was reading in the Examiner a critique of Judge Breyer's dissertation and citing of 3 or 4 cases on Wednesday, and I was interested in your critique of his performance. And after the break's fine.
Thank you. Breyer's questions, what did they suggest, and what did you think of his performance? Again, I think all those guys were under-enthused, but we'll see what the expert David Rivkin says when we come back. David Rivkin stays with us. Thanks so much, David, for doing this. This is great. A lot of people are reacting the same way I am. You didn't say this was gospel, but you said chances are today or very soon after the argument, they're sitting and voting, right?
That is correct. Today is the conference. It's Friday morning, and it's after the oral arguments, so the chances are very high that they will vote on it, and the justice will be assigned to write the opinion.
So it's not, again, for the worriers out there, we still have more worriers on the phone. They want you to be right. They're just worried that you're not. Is that, well, all right, that was 3 days, but now they have 6-8 weeks, and people will get to them, and then they'll change their mind. But they're probably voting now or very soon.
It happened in less important cases that justices have changed their mind because dissent circulated and they find it persuasive, but it's highly unlikely.
Okay.
I would be amazed if that would have happened.
Let's go to Victoria, who thinks you're getting her hopes up, and she's not sure. Go ahead, Victoria.
Good morning. While your enthusiasm is infectious, I just wondered if you could potentially turn your mind and tell us how you think they would articulate a reason for not striking down the individual mandate.
Okay.
Well, there's a glimmer of that, which some people got it. Thank you. Excellent question.
Excuse me. I ignored the Breyer question, too, if you could fold that in somehow.
Sure. Briefly about Breyer, far be for me to say that any Supreme Court justice can be wrong about matters of law, but what the caller may be referring to, there's a little colloquy between Breyer and my good friend Paul Clement, where Breyer sort of asking him, invoking the famous case, McCullough, Chief Justice Marshall's case involving the Bank of the United States, for the proposition, well, you're saying, Mr. Clement, that Congress cannot create commerce, but wasn't commerce created there by creating the bank? And Clement said quite trenchantly that, first of all, the McCauley is not a Commerce Clause case, which it wasn't. But, I mean, I don't think it's a matter of mistake. I think it's a matter of spirited repartee. And I think Justice Breyer is one of the best justices on the court. As far as this question is concerned, look, there's a little bit a glimmer of that in the last observation made by Justice Kennedy during the second day, where he was sort of musing aloud whether or not, because there's a very, how he put it, extraordinary proximity between the decisions of a 26-year-old not to purchase insurance and the impacts on the not just medical insurance, but the not his word, I would use the word healthcare footprint in terms of what healthcare you consume and at what cost. You can try to say that this is a unique that this is unique. The limiting factor here is that it's unique, and the government, of course, has been arguing that since the very beginning. I honestly don't think this dog would hunt because there's nothing unique about healthcare. Let me tell you briefly. Even if you assume that healthcare market is unique and different from market for nutrition and hydration and transportation and housing, if your proposition is that because your behavior today of not buying insurance has a sufficiently large footprint in the future on the healthcare delivery market, then every single decision you make as an individual can be mandated because your decision to marry or not to marry, your decision to get an education or not get an education, not to get medical checkups, lead a sedentary lifestyle, have bad diet, all those decisions have enormous footprint as far as healthcare is concerned. So you can pour out an infinite variety of mandates just for the prism of medical of healthcare delivery. So this argument doesn't work. And frankly, I cannot write such an opinion, which I don't think, which is why I don't think it would be written.
Okay, Victoria, you want to say anything? Response?
No, I'll only thank you for that. And I just only hope and pray you're right. That's all I can say. So,
thank you.
Thank you very
much. I
much.
pray too, by the way, every day.
Good, in addition to analysis. Fine. All right, what else did we miss? What else? We have a minute left. Was there anything interesting that happened that you noted that surprised you?
Again, I think the extent to which a number of justices is seriously contemplating taking down the whole statute was very impressive. And, very importantly, the extent to which virtually all justices were seriously engaged in Medicaid. To be clear, we are absolutely right that Medicaid this recovery of Medicaid isn't constitutional. But unlike the case with an individual mandate, the case where we're squarely within the four corners of existing case law, every single case for the last 200-plus years is supporting us. There are just not many cases in this area, and the extent to which they were seriously engaged in this issue, I found very pleasing, even exhilarating.
When you were prescient, you said you thought it should go down, the mandate, and you thought it would. I thought it should, but I wasn't so sure. You saw this coming. I didn't. I mean, at least I hope you were right.
I've been a believer in this issue from the first time my colleague Lee Casey and I spotted this. As a matter of fact, Bill, very briefly, not even in 2009, we wrote about it the first time in 93 because, as you may recall, the individual mandate is a hardy perennial of these reforms. It was part of Hillary Care.
That's right. Okay. Good. You sure did. And we read everything you guys write. Thank you very much.
Good to be with you.
David, thank you very much. Enjoy your weekend, and thanks for ending your week with us. I hope you're ending your week. David Rivkin, partner at Baker Hostetler.